Hi, this is Daryl Tuttle, and welcome to another episode of the Boom X Show, Laws of Money. Today, we are going to cover the 3 ways you can pass wealth to your spouse. 3 ways. The first is testamentary trust. The second is by a living trust. And the third is outright. Testamentary trust is the first way that you can pass wealth to your spouse when you pass away. And testamentary means death, essentially. Fun fact, it comes from the Middle Ages, the last will and testament. A will in the Middle Ages, in common law, British common law, was a written instrument that passed wealth, conveyed wealth, like a deed. That's what we call it today. A testament was a written instrument that passed personal property, like a table or something tangible that you can carry with you, essentially. By the way, financial accounts are considered personal property. So real estate transfers by will and personal property by a testament. Well, today we've just combined that in modern ages to last will and testament. And so when you hear that word testamentary, it refers to the process of passing wealth from a living person who owns the property but then passes, transferring wealth from a deceased asset owner to a living qualified heir. That means testamentary. Now, inside a last will and testament, you can absolutely create a trust. A trust. Now, a trust is a legal construct that owns property, assets, real estate, or personal property. It can be created during your lifetime, a living trust, or it can actually be created inside of a last will and testament. The trust has to be specified and laid out in the last will and testament. When the will is signed and witnessed, and in some jurisdictions notarized, when that happens, then the last will and testament is legally effective. Now, the trigger event for the trust inside of the will is death. Testamentary. So a last will and testament is a document that conveys wealth from a deceased asset owner to a living person. You can convey it outright in a last will and testament, or you can convey it to a trust that's inside of the will. Now, a last will and testament must be probated. I'm not going to discuss the pros and cons of probate in this video, but I plan to make a video about probate and disabuse some of the myths about probate later on. Now, for your spouse, your choices are to create a last will and testament and a trust inside of it. When I pass away, I give my entire estate to my spouse, but in trust. It's at that point when you pass away that the trust is created, becomes legally effective in the probate, and assets are transferred from what you own during your lifetime into the trust for your spouse's benefit. Now, there's a key advantage, a significant advantage to doing it that way. It is so important that it is my view that you, in almost all cases, want to use a last will and testament to convey to your spouse. And here's the reason. Under federal law, 42 U.S.C. 1396 in particular, federal law allows you to create a trust inside of your will in which you leave your estate to your spouse. That's her inheritance. Now, that inheritance, if it's inside of a will and has certain language in it, that wealth is protected from brutal Medicaid spend-down rules. Now, just imagine if you're in your 40s or 50s or 60s, which is the age in which you should be thinking about estate planning and asset protection for you and your spouse. Just imagine, have a leap of faith, that, oh, I might live a little bit longer. Just imagine leaving your spouse behind when she is in her 80s and she's now alone. Now, if we create this trust inside the last will and testament, rather than leaving it to her outright so she owns it, if she trips and falls and breaks a hip or has dementia, just needs assistance with long-term care, what will happen otherwise is money will just start flying out the window. I've seen long-term care costs as high as $12, $14, $15, even in one case, $30,000 per month. Now, if we create a bulletproof silo, a 14 USC trust that must be created by a last will and testament, if we do that, then the assets inside of that trust are not subject to Medicaid spend downs. The 5-year look back period does not apply. Transfer penalties do not apply. It is by far the single best asset protection trust in American jurisprudence, but it must be created in the last will and testament. We call that a testamentary trust. That particular trust is called a spousal protection trust. The other way to convey wealth to your spouse is a living trust, a living trust. Now, the important difference between a testamentary trust and a living trust is that for tax purposes and Medicaid purposes, a living trust does not exist. I want to repeat that. You probably have heard a lot about living trusts. Your neighbors in the barbecue, people at the church picnic, your attorney, your financial advisor. It seems like everybody's talking about living trusts. What's fine. Living trusts have a purpose, serve a purpose, and it's most notably used for conveying wealth without probate for single people. The reason we do not use a living trust for married people is because we cannot protect the assets of the surviving spouse, her inheritance, with a living trust. A living trust only avoids probate. And what I mean by that is we can create a trust during your lifetime. We can transfer assets into the living trust during your lifetime. We have to record a deed that transfers the personal residence into the living trust. For tax purposes, it's disregarded. The living trust does not exist. That's why with a living trust, you still file all of interest income and dividends and all of the taxable events for your investments on your 1040. In fact, you can tell the difference between an asset protection trust and a simple probate avoidance trust that does nothing but avoid probate by the tax return. If you're still filing your 1040, the trust does not have any asset protection features at all. So a living trust is used to transfer assets during your lifetime. The only benefit for doing that is when you pass away, you avoid probate. Once again, a probate is necessary for a spousal protection trust. The next way you can, the third way and the final way you can convey wealth to your spouse is outright. Now, I cannot give you advice one way or the other on a video on which method to use, but think about it. Outright means we can use a transfer on death deed in some jurisdictions that simply vests title in the surviving spouse when you pass away. Or we could use a community property agreement if, in those states that are, if Texas, California, Washington, some others, Wisconsin. In those states, we can use a contract that conveys wealth to the surviving spouse without probate. You can also use beneficiary designations at your bank and your financial institutions. Life insurance can vest automatically in the name of the surviving spouse. Now, we call that an outright distribution. We're not using a trust in a last will and testament, and we're not using a living trust. We're just dying, and then magically title vests in the surviving spouse. Now, the disadvantage to that is obvious. If you pass away and your surviving spouse is in her 80s, is suffering from ill health, or just needs assistance with activities of daily living, and is in an assisted living facility at $8,000 a month, and you leave her everything outright, she now owns it. She will be required to spend her inheritance down to $2,000. Yes, a personal residence does not count as an asset if it's under certain limits in terms of equity. However, don't forget, eligibility rules are different than recovery rules. And even though Medicaid does not count the personal residence, they're going to slap a lien on that thing so fast, it'll make your head spin, right? Now, outright distribution, it's up to you. But if your spouse owns her inheritance outright, it's subject to spend down for long-term care purposes, unreimbursed medical expenses. So let's go over it. The 3 ways to convey wealth to your spouse. Number 1, testamentary. The advantage is the Spousal Protection Trust. Number 2, a living trust, only avoids probate. Number 3, outright distribution. Just like a living trust, outright distribution subjects the inheritance of your spouse to Medicaid spend down rules, 5-year look back period, and transfer penalties. That's it. 3 reasons, or 3 ways to convey wealth to spouse. In the next episode of the Boom X Show, we'll talk about the Spousal Protection Trust in more detail. Until then, peace out.